By 1880, if you lit a lamp in New York, heated a factory boiler in Cleveland, or bought a can of kerosene at a country store in Kansas, there was a very good chance that oil had passed through the hands of one company before it reached you. Not most of the oil, nearly all of it. Standard Oil controlled somewhere between 90 and 95% of the refining capacity in the United States, a concentration of economic power with no precedent in American life, and no law standing against it. There was no federal statute that made it illegal for one man to own an entire industry. If you're enjoying this story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. There was no agency to call, no commission to petition, no court built for the problem. John Davison Rockefeller had not broken any law, because the law required to stop what he had built did not exist yet. He had simply moved faster than Congress, faster than the state legislatures, faster than the courts, and by the time Washington understood what had happened, the oil business of an entire nation answered to a single office in Lower Manhattan. It would take another decade for the country to write a law broad enough to reach him, and even then, that law would spend years failing at the one job it was written to do. For most of the first century of the American Republic, a corporation was not what it would later become. State legislatures granted charters one at a time, each written for a single specific purpose: a turnpike, a bridge, a bank, a canal company, and the charter defined exactly what the company could and could not do. A corporation chartered to build a bridge could not decide on its own initiative to start manufacturing rope or buying up neighboring bridges. It could not own stock in another corporation unless its charter specifically allowed it, and most charters said no such thing. This was not an oversight. Early American lawmakers, remembering the abuses of chartered monopolies like the East India Company, were suspicious of concentrated corporate power and built that suspicion directly into the law. A corporation was a narrow, purpose-built legal creature, tightly bound to the state that created it. The idea of one company quietly buying its way into control of an entire national industry was not something the law anticipated, because nothing on that scale had existed yet to anticipate. That began to change in the decades before the Civil War, as states moved away from granting charters one legislative act at a time and adopted general incorporation laws instead, statutes that let any group of investors form a corporation for almost any lawful business purpose simply by filing paperwork, without asking a legislature for special permission. New York passed an early version of such a law in 1811, and most other states followed over the next several decades. The change was meant to democratize incorporation, to take the decision out of the hands of legislators who could be bribed or lobbied, and put it within reach of any group of investors with capital and an idea. It succeeded at that. It also removed the one mechanism, case-by-case legislative review, that had kept the size and purpose of American corporations deliberately narrow, and it did so at the exact moment railroads, telegraph lines, and industrial manufacturing were making national scale possible for the first time. John D. Rockefeller entered the oil business in Cleveland in 1863, still in his early 20s, backing a refinery with money he had made as a produce commission merchant. Oil refining in those years was a chaotic, overcrowded trade. Dozens of small operators in Cleveland alone competed to turn crude petroleum, freshly discovered in western Pennsylvania, into kerosene for lamps, and most ran on thin margins and thinner judgment. Rockefeller looked at that chaos and decided the solution was not to compete inside it, but to end it. He incorporated Standard Oil of Ohio in 1870 with a handful of partners, and from the beginning his method was not to build a better refinery than his rivals. It was to make his rivals' refineries worthless to their owners, one at a time, until they had no real choice left but to sell. The tool he used first was the railroad rebate. In 1872, Rockefeller and a small group of refiners organized a company called the South Improvement Company and negotiated a secret arrangement with three major railroads: the New York Central, the Pennsylvania Railroad, and the Erie. Members of the South Improvement Company would ship oil at a discounted rate. Non-members would pay the full published rate, and a portion of what the non-members paid would be secretly funneled back to South Improvement Company members as a rebate charged against their own competitors' shipments. A rival refiner would pay to ship a barrel of oil, and without knowing it, part of that payment would end up in Rockefeller's account. When word of the arrangement leaked, independent producers in the Pennsylvania oil regions revolted. Boycotts and public outrage forced the railroads to cancel the contracts within weeks, and the South Improvement Company never shipped a single barrel under its own name. But the episode taught Rockefeller something durable. Freight rates, not refining efficiency, were the real lever of control in the oil business, and he spent the next decade privately rebuilding that advantage through deals the public never saw. It would be inaccurate to say Rockefeller won purely through rebates and threats. Standard Oil also ran its refineries with a discipline that was genuinely unusual for the industry, squeezing profit out of byproducts that competitors threw away, manufacturing its own barrels instead of buying them, and building pipelines that let it move oil more cheaply than anyone shipping by rail alone. The efficiency was real. What made it decisive, though, was that Rockefeller paired it with pricing and freight advantages that no competitor operating honestly could match, so that even a well-run independent refinery eventually found itself competing against a company that controlled the tracks its oil traveled on. The immediate result of the scandal became known, in Cleveland, as the massacre. In the 6 weeks after the South Improvement Company deal became public in early 1872, Rockefeller approached one Cleveland refiner after another, using his freight cost advantage and his access to capital to make each of them an offer they understood, correctly, that they could not refuse. 22 of Cleveland's 26 refineries sold to Standard Oil in that span, most for cash, some for Standard Oil stock that would later make their former owners wealthy men, and a handful for very little at all. Rockefeller described the strategy in later years as an insurance policy against the wasteful overbuilding of refining capacity that plagued the industry. His competitors, less charitably, called it what it looked like from the outside, a company using its size to make survival outside the company impossible. By 1880, the process that began in Cleveland had repeated itself across the country. Standard Oil controlled refineries in Pittsburgh, Philadelphia, New York, and Baltimore, and it had built or acquired its own pipeline network to move crude oil without depending on the railroads it had once needed rebates from. It employed men whose job was to track the shipments of the remaining independent refiners, sometimes through informants inside rival companies and inside the railroads themselves, so that Standard Oil could undercut a competitor's price in a specific city at the exact moment that competitor tried to make a sale. Independent refiners who survived this pressure often found that Standard Oil would buy their oil at fair prices and let them keep operating, so long as they never expanded and never advertised. The ones who refused faced prices below the cost of production in their local market until they sold or went under. By the time anyone bothered to count, Standard Oil controlled somewhere close to 95% of the oil refined in the United States. One company processed nearly every gallon of kerosene the country burned. The consolidation was not without its defenders even outside the company. The retail price of kerosene fell substantially over these same years, from roughly $0.25 per gallon in the late 1860s to a few cents per gallon by the mid-1880s, and Rockefeller's supporters pointed to that decline as proof that consolidation had delivered real efficiency to ordinary households. What that defense left out was the position of everyone who was not a customer, an independent refiner who tried to enter the business, or a producer who wanted an alternative buyer for crude oil, found almost no market left to enter, regardless of how cheap the finished product had become for the family lighting a lamp with it. There remained, however, a legal problem, and it was not a small one. Standard Oil of Ohio was chartered under Ohio law, and Ohio law, like the law of nearly every other state, did not allow a corporation to own stock in another corporation. Rockefeller now controlled dozens of refining companies scattered across a dozen states, but he controlled them the way a man controls property he is not legally permitted to hold, through personal trust, private agreement, and the loyalty of men who held stock on his behalf but answered to him directly. It worked, but it was fragile, hard to manage, and legally precarious. Rockefeller's chief lawyer, Samuel Dodd, had told him for years that the arrangement was a legal house of cards. In 1882, Dodd built something sturdier. Dodd's solution was the Standard Oil Trust, and it was less a business innovation than a legal one. Under the trust agreement, the shareholders of every company Rockefeller controlled, more than 40 of them by then, exchanged their stock for trust certificates, issued by a board of 9 trustees with Rockefeller at its head. The trustees now held, in trust, the shares of every one of those 40 companies, and the certificates paid dividends to the men who had once been shareholders directly. On paper, each individual company remained a separate legal entity, chartered in its own state, obeying its own state's laws, run by its own officers. In practice, every decision of real consequence, pricing, production, expansion, acquisition, ran through the 9 trustees in New York. The trust did not violate the letter of any state's corporate law, because no state law had been written with this structure in mind. It was the first time an American company had figured out how to be, in every meaningful sense, a single national enterprise while remaining, on every piece of paper that mattered to a court, dozens of separate and unrelated companies. Other industries noticed immediately. Within a few years of the Standard Oil Trust, similar arrangements appeared in sugar, where the American Sugar Refining Company came to control roughly 98% of the country's sugar refining, in whiskey, where distillers organized the Whiskey Trust in 1887, in lead, in cottonseed oil, in linseed oil, in the manufacture of matches, in twine and rope, in the production of salt. A family buying the ordinary contents of a kitchen pantry by the late 1880s could find that the sugar in the bowl, the kerosene in the lamp, and the whiskey in the cabinet were each supplied by a single dominant combination, three separate trusts with three separate boards, but a shared basic method: buy the competition, fix the supply, and set the price without any market pressure left to answer to. Newspapers began using the word trust as a general label for any large combination that had swallowed its competitors, whether or not it used Dodd's specific legal structure, and the word stuck in the public imagination long after most of the original trusts had been reorganized into other legal forms. By the late 1880s, farmers who watched the price of what they bought rise while the price of what they sold fell, small manufacturers undercut by combinations with cheaper capital and better freight rates, and ordinary consumers who paid whatever a monopoly refiner or a monopoly sugar company chose to charge, had all arrived at roughly the same conclusion. Something had gone wrong with American business, and nobody in Washington seemed to have the authority to fix it. Farmers had organized earlier and louder than almost anyone else, forming Grange chapters across the Midwest through the 1870s to demand state regulation of the railroads that set the freight rates controlling both what they paid to ship grain and what men like Rockefeller paid to ship oil. That pressure produced the Interstate Commerce Act of 1887, the first federal law regulating a major industry, and the first real acknowledgement that some economic problems crossed too many state lines for any single legislature to solve. It targeted railroads specifically, not the trusts that used them, but it established the principle that Congress could regulate interstate commerce directly, and reformers pushing for a law against the trusts pointed to it as proof that Congress had both the authority and, potentially, the will. Journalists and reformers had been documenting the pattern for years before Congress acted. The writer Henry Demarest Lloyd published an essay called The Story of a Great Monopoly in the Atlantic Monthly in 1881, laying out how Standard Oil had used railroad rebates and predatory pricing to destroy its competitors, and it was read widely enough that Standard Oil's methods became a subject of national conversation years before any law targeted them directly. State legislatures tried to respond on their own. Several states passed laws in the 1880s attempting to restrict combinations in restraint of trade, but a state law could only reach a company operating inside that state's borders, and a trust with refineries in a dozen states could simply concentrate its most vulnerable operations somewhere with a friendlier legal climate. The problem was, by its nature, a national one, moving goods and capital across state lines faster than any single legislature could regulate, and only Congress had the constitutional authority to reach commerce that crossed those lines. The question was whether Congress would use it. By 1888, both major parties had put language condemning trusts into their national platforms, less out of conviction in either party's leadership than because the issue had become too popular with voters to ignore. Neither platform offered much in the way of specifics. In 1890, Congress finally acted. The bill was introduced by Senator John Sherman of Ohio, a Republican who had spent decades in Washington and who happened to represent the very state where Standard Oil had been founded and still kept its nominal headquarters. On the Senate floor, Sherman argued that if the country would not tolerate a king exercising political power, it should not tolerate a trust exercising unchecked economic power over the necessities of life, a line that captured the popular mood of the moment more precisely than the bill's own legal text managed to. If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. The Senate passed the bill 51-1. The House passed it by voice vote, with barely any recorded opposition. President Benjamin Harrison signed it into law on July 2, 1890, and the country had, for the first time, a federal statute making it illegal to form a combination in restraint of trade or to monopolize any part of interstate commerce. The core language ran to a single sentence: every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states, was declared illegal. It was sweeping in scope and almost entirely silent on the details. It did not define a trust, did not specify what made a restraint unreasonable, rather than merely inconvenient to a competitor, and created no new federal agency to investigate or enforce it. Responsibility for bringing cases fell to the Department of Justice, a department with a small staff, a small budget, and no particular mandate from the administrations of the 1890s to make trust-busting a priority. The vagueness was not entirely an accident. A law specific enough to name Standard Oil, or to define precisely which arrangements were forbidden, would have been easier for corporate lawyers to draft around, the way Rockefeller's own lawyer had drafted around Ohio's corporate law a decade earlier. A broad prohibition, applied by courts case by case, was supposed to be harder to evade. But broad language cuts in more than one direction, and the courts asked to interpret the Sherman Act in its first years did not read it the way its authors had hoped. The first major test came in 1895 in a case against the American Sugar Refining Company, which controlled somewhere close to 98% of the country's sugar refining capacity after acquiring 4 of its largest remaining competitors. The government argued that this was exactly the kind of monopoly the Sherman Act existed to break up. The Supreme Court disagreed, and its reasoning gutted the statute for the better part of a decade. The court ruled that manufacturing, the actual business of refining sugar, was not itself commerce among the states, even though the sugar was later shipped and sold across state lines. Commerce, in the court's reading, meant the buying, selling, and transporting of goods, not their production. A company could own every sugar refinery in the country and still not violate a law aimed at restraints on interstate commerce, so long as the monopoly existed at the manufacturing stage rather than the shipping stage. It was a distinction that made almost no practical sense outside a courtroom, and it meant that for years after the Sherman Act passed, the law that was supposed to break up industrial monopolies could not reach the manufacturing monopolies that had prompted it. In the years after the ruling, the Department of Justice brought only a handful of Sherman Act cases against industrial combinations through the rest of the 1890s, and won almost none of them. Standard Oil's own lawyers studied the Knight decision closely and concluded, correctly, that so long as the company's activities could be framed as manufacturing rather than the interstate movement of goods, the new federal statute posed little practical threat to the structure Samuel Dodd had built. Where the Sherman Act did prove useful in its first decade was in a direction almost nobody had intended. In 1894, during the Pullman Railway strike, federal courts issued an injunction against striking workers under the Sherman Act, reasoning that a coordinated strike interrupting rail traffic across state lines was itself a restraint of interstate commerce. The Union leader Eugene Debs was jailed for defying the injunction, and the Supreme Court upheld the use of the antitrust law against the Union in a case called In re Debs. A law drafted to restrain concentrated economic power spent its first years being used more often against striking workers than against the industrial trusts named in its own legislative history. Standard Oil, meanwhile, kept operating almost exactly as it had before the law passed. The trust structure itself did eventually run into legal trouble, though not from Washington. In 1892, 2 years after the Sherman Act, the Ohio Supreme Court ruled in a suit brought by the state's Attorney General that the Standard Oil Trust violated Ohio law by allowing an Ohio corporation's stock to be controlled by out-of-state trustees, and ordered the trust dissolved. Standard Oil complied, on paper. The 9 trustees formally returned the shares of the Ohio company, and the trust certificate structure Samuel Dodd had built a decade earlier was dissolved exactly as the court ordered. In practice, very little changed. The same men who had run the trust simply kept running the same companies through informal agreement, while their lawyers searched for a new legal form that state law could not touch. They found it in New Jersey, which in 1889 had passed a law, quietly and without much public attention, permitting a corporation chartered in that state to hold stock in other corporations, anywhere in the country, without limit. In 1899, Rockefeller's organization reincorporated as Standard Oil Company of New Jersey, a holding company that could now legally own the stock of dozens of subsidiaries outright, achieving through a New Jersey charter exactly what the trust certificates had achieved informally, in a way no court, state, or federal had yet found grounds to challenge. Public pressure, rather than legal pressure, is what finally forced the issue back into the open. Between 1902 and 1904, the journalist Ida Tarbell published a 19-part investigation of Standard Oil in McClure's magazine, later collected into a book, built on years of research into court records, testimony, and interviews with men who had competed against Rockefeller and lost. Tarbell's own father had been an independent oil producer squeezed out during the years of railroad rebates, and her account traced the company's rise in granular, documented detail from the South Improvement Company scheme through the trust to the New Jersey reorganization. She documented, with copies of the underlying contracts, how the railroad rebates had continued in various forms for decades after the South Improvement Company scandal supposedly ended them, and how Standard Oil had used a related device called the drawback, collecting a payment from the railroad on every barrel a competitor shipped, not merely a discount on its own. The series became one of the most widely read works of journalism in the country, and it did something the Sherman Act's vague language had never managed on its own. It gave the public a specific, factual, chapter-by-chapter account of exactly how one company had come to dominate an entire industry. At the moment, a new president in Washington was looking for exactly that kind of case to make. Theodore Roosevelt had become president in 1901, and unlike his predecessors, he treated the Sherman Act as a tool to be used rather than a formality to be observed. Roosevelt drew a public distinction between what he called good trusts, large combinations he believed operated efficiently and served the public, and bad trusts, which he believed used their size specifically to crush competition and extract higher prices, and he framed his administration's antitrust suits as an effort to sort one from the other rather than to break up big business as a matter of principle. His administration's first major antitrust victory came in 1904 in a case against the Northern Securities Company, a railroad holding company organized by J.P. Morgan, James J. Hill, and E.H. Harriman to combine control of two competing transcontinental railroad systems. The Supreme Court, by a narrow 5-4 vote, ordered the company dissolved, ruling that combining two competing systems into a single holding company was exactly the restraint the Sherman Act prohibited, regardless of the earlier sugar ruling. The decision reopened the door the 1895 ruling had closed, and the Roosevelt administration turned next, deliberately and publicly, toward Standard Oil. The federal suit against Standard Oil Company of New Jersey was filed in 1906, working through the federal courts for 5 years before reaching the Supreme Court. The government's case drew directly on the history Tarbell had documented: the railroad rebates, the Cleveland acquisitions, the deliberate underpricing used to force independent refiners to sell, and the New Jersey holding company structure that let a formally dissolved trust keep operating as a single enterprise in every way that mattered. By the time the case reached the Supreme Court, competition from newly discovered oil fields in Texas and California, and from rivals like Gulf and the Texas Company, had already pulled Standard Oil's share of national refining down from its earlier peak to something closer to 64%, still dominant, but no longer the near total control it had held 30 years before. On May 15, 1911, the Supreme Court ruled against Standard Oil and ordered the company broken apart into 34 separate and genuinely independent companies, among them Standard Oil of New Jersey, Standard Oil of New York, and Standard Oil of California, each required to operate under its own board and its own ownership, forbidden from coordinating prices or territory the way the parent company once had. In the same decision, the court introduced what became known as the rule of reason, holding that the Sherman Act did not prohibit every large business, only those that restrained trade unreasonably, a doctrine that gave future courts far more discretion than the bare statutory language of 1890 had ever offered. What happened next surprised almost everyone who had spent years fighting to break up Standard Oil. Rockefeller, by 1911 mostly retired from active management and already known publicly as a philanthropist, held stock in all 34 of the new companies in roughly the same proportion he had held in the old one. In the months after the breakup, the combined market value of those 34 companies' shares rose sharply, as investors, freed from the uncertainty of the pending court case and able to value each business on its own merits for the first time, bid the stock up. Rockefeller's personal fortune, tied up entirely in those shares, grew larger after the breakup than it had been before it, and within a few years he was widely regarded as the richest private citizen in American history to that point, with a fortune estimated at close to $1 billion at a time when $1 billion was a sum most Americans could not meaningfully picture. The government had spent 5 years and a Supreme Court case dismantling the largest industrial monopoly the country had ever produced, and the man at the center of it walked away wealthier than before the case began. Several of the companies born out of that breakup are still operating today under different names, having merged and split and merged again over the following century. Standard Oil of New Jersey eventually became Exxon. Standard Oil of New York eventually became Mobil, before the two merged back into ExxonMobil in 1999. Standard Oil of California became Chevron. The empire the Sherman Act was written to dismantle did not disappear. It reorganized into pieces large enough, individually, to remain among the largest companies on Earth more than a century later. Congress did try to close some of the gaps the Sherman Act's vague language and the court's narrow early rulings had left open. In 1914, under President Woodrow Wilson, Congress passed the Clayton Antitrust Act, which named specific practices as illegal rather than leaving everything to a judge's interpretation of one broad sentence: price discrimination intended to destroy competition, exclusive dealing arrangements that locked out rivals, mergers that would substantially lessen competition, and interlocking directorates that let the same small group of men sit on the boards of companies that were supposed to be competing with each other. The same year, Congress created the Federal Trade Commission, an agency built specifically to investigate unfair business practices, work the Justice Department had never had the staff to pursue on its own. The Clayton Act also stated plainly that labor unions were not to be treated as illegal combinations in restraint of trade, a direct answer to the way the Sherman Act had been turned against striking workers in its first years, rather than against the trusts. None of it happened quickly, and none of it happened because Congress anticipated the problem in advance. Every piece of the eventual system, the hurried and vague language of 1890, the narrow court ruling that gutted it within 5 years, the ironic use of it against labor before it was ever used against a trust, the state court dissolution that Standard Oil complied with on paper while changing nothing underneath, the New Jersey loophole that let the whole structure reconstitute itself legally, came into being only after Rockefeller had already built something the law had never been designed to prevent. Standard Oil became what it became in the 20 years before anyone in Washington wrote a law broad enough to reach it, and the law spent the 2 decades after that trying, with mixed and often accidental success, to catch up. The pattern did not end with oil. In 1998, the Justice Department sued Microsoft under the same 19th century statute, arguing that the company had used its dominance of desktop operating systems to crush competing web browsers in a manner not so different, in principle, from a 19th century refiner using freight rebates to crush a competing refinery, and a federal court ordered the company broken up before an appeals court later replaced that remedy with a set of behavioral restrictions instead. More recently, federal and state regulators have brought Sherman Act cases against Google over its dominance of online search and advertising technology, and against Amazon and Meta over practices that critics describe, in language that would sound familiar to anyone who read Ida Tarbell, as the deliberate use of scale to make survival outside the dominant platform increasingly difficult for smaller competitors. Each of these cases has moved through the courts far more slowly than the underlying technology it addresses, in much the same way the Sherman Act itself trailed Standard Oil by 20 years and then took another 2 decades to be applied with any real force. A century after Rockefeller's oil empire was ordered into 34 pieces, the same basic question Congress tried to answer in 1890, what should be done about a company that has grown too large for the market to discipline on its own, remains one that Washington answers slowly, unevenly, and almost always after the company in question has already built whatever it set out to build. Thank you so much for watching until the end. If you love this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.